On the judiciary, the state, the very recent drama that has plagued the executive and the judiciary, the antagonism that has been ongoing and how this is affecting the inner workings. How better could that situation or relationship unfold? And still with us is Senator Moses Kajwang, as well as lawyer Steve Ogola, who shall be giving us insider information and obviously insights that we wouldn't have into how this is playing out and how better this could be handled. But before that, let's take the story that could actually give us more insight into it. Chief Justice and President of the Supreme Court, Justice David Maraga, last week decided to take the head of state on after what he termed as failed attempt to secure an appointment with him. In his fiery address to the media, CJ Maraga opted to address the president personally, reminding him that he swore to defend and uphold the Constitution and the laws of Kenya. Our reporter Duncan Haimba sought to revisit the restrained relationship between the two and brings us this report.
Your Excellency, I want to address the President personally.
It is round two as Chief Justice David Kenani Maraga once again takes the President head-on in what he calls
with the contemptuous utadu attitude. How can we expect God to bless our nation when we are so callous to the most desperate in our society?
In November last year, the head of the judiciary lamented over what he termed calculated move to starve his arm of government resources in order to cripple services.
They want to control the judiciary. They want to make the judiciary a puppet.
You need more money. But CJ, your courts are the same ones. When we propose certain tax measures, you are the first ones to say injunction. Sasa pesa hii itatoka wapi? Where will it come from?
A fight between the executive and the judiciary that clearly has a history that dates back to 2017.
Some CSS and the PSS are bragging that the CJ will or should be removed before the end of this year. Really? Kumbe hii nchi kuna wenyewe. Some of us are serving at their pleasure.
Na tukishamaliza tutarevisit hii mambo yenu. Ndipo tunauliza kila saa, kila pahali tukienda. Jaji amesema, tunafanya kazi hii, unakuja una block, unaweka injunction. Kwa hiyo unafikiria wewe umechaguliwa na nani? No, there's a problem and we must fix it. Going forward, we must fix it.
We are tired of being the punching bag all the time.
Mimi nataka niwaambie wenye koti, tumewaheshimu. Lakini msifikirie heshima ni uoga.
The President of the Supreme Court accuses the head of state of blatantly disregarding court orders.
It is for this reason that I must remind you, Your Excellency, that you swore to defend and uphold the Constitution and the laws of Kenya.
We have seen independence of the judiciary. Yes, we have seen them making major dramatic rulings even against the government. Muko kila siku huko mnatupatia injunction stopping us from doing our work. Lakini ni haki yenu, tunaendelea. Tutawafuata tu huko mbele.
Last year, the Chief Justice made good his threat and skipped Jamhuri Day celebrations as a sign of protest.
I have decided that unless I'm treated with the dignity due to my office, I will choose which of those state functions I will attend.
But when they met early in the year, the two seemed to have made peace.
Me, I'm not in any fighting mood with anybody.
CJ Maraga is set to leave office next year when he attains retirement age. Duncan Haimba, KTN News.
But until then, it is yet to be seen how that is going to unfold. A very antagonistic relationship there between the executive and the judiciary, and even from the verbally they have expressed that all is not well. But at the end of the day, this is all about the common mwananchi who's set to benefit from both arms of government. Now, as I told you earlier on, we have Senator Moses Kajwang with us on this discussion, as well as lawyer Steve Ogola. And I'll start by reminding you, obviously, if you're watching at home, that you can actually be a part of the conversation by answering our question this morning. But aside from that, let's get into it. Those have been promises that, as Duncan Haimba has covered, that the executive is going to revisit. There shall be a sort of punishment for not abiding, while the CJ on the other hand feels that he is being forced, or rather the judiciary is being forced into a form of puppetry that, of course, he does not want to hearken to, because this is a body that is set or is expected to be independent, as has been set up in the Constitution. I'll start with you, Senator Kajwang. What do you make of this, and is it true that this is a sort of revisiting, as was promised earlier on by the executive?
Well, there are a few things that the CJ has said,
yes,
some of which all Kenyans can agree with. Number one, it is not a secret that the judiciary has not received the funding that it has requested.
Sure.
For example, we had a high court that was being built in Homabay Town. It was supposed to have been completed in 1 year's time. It is stuck because of funding challenges. When you have courts at county levels, it means that administration of justice becomes easier. People don't have to travel too far to get justice. And so that defunding has affected the operations of the judiciary, and it is not secret. The other one is the impunity around court orders. It is not a secret that this government has defied court orders at all levels, be they for political players, be they for at commercial level. It is not. We cannot be talking of a country that upholds the rule of law when the executive that has got the monopoly and the instruments of violence and power is in open defiance of the orders of the court. That is not, a secret. So the CJ is just saying what everyone believes.
Right.
The third thing is on the issue of staffing, and particularly on issues of judges that has resulted in backlog. It is not a secret. And on those three issues, I agree with the CJ 100%. The only two issues that I cannot confirm is whether he has been denied an appointment, and if that was so, then that would be quite contemptuous of the judiciary. And the other one is on the issue of the manner in which he has been treated. It is perfectly all right, in my view, for the CJ to ventilate. It is perfectly all right, in my view, for the CJ to stand up and speak on behalf of the institution that he heads. But there's been a very sad erosion of institutions in this country. Even we in Parliament, we have seen situations where people go to State House to get directions. That is playing out. Senate has been a fairly, strong and progressive and independent-minded institution, but we're now seeing part of the political, groupings are getting direct instructions from the executive. And so Parliament is being neutered, the judiciary is being neutered, independent commissions have been neutered, and I think the president is following bad advice as far as respect for institutions enshrined in the Constitution are concerned. He can still be a great president and allow Parliament to be great. He can still be a great president and allow the judiciary to be great.
Absolutely. And when you see the CJ standing there in front of the media addressing some of the issues that he is facing, you would expect that Parliament then would have at least a voice in this whole matter. How could you detail to us how exactly Parliament has been left without recourse in terms of holding the executive to account?
When I saw my colleagues visit the Chief Justice yesterday, I thought that it was a good move for them to touch base and find out ways in which the judiciary and Parliament, particularly the Senate, could work together to iron out the issues that are emerging between the judiciary and the executive and the legislature. Remember, issues of budgetary allocation or issues of budgets are now the domain of Parliament. And so when we talk of the judiciary not getting the money that it requires to run its programs, part of the blame is on Parliament. How do we do the budget process? Who are the people in the budget committees? Who are the people in Parliament who would accept that the budget of the judiciary be cut down? In fact, it is so wrong if MPs and senators are cutting budgets that would have gone to building courts in their respective domains, and which would have resulted in better justice to the people that they serve. So yes, there's some point of blame on Parliament, and I hope that the conversation between Pogisio and Irungu Kang'ata and the CJ was focused on that. But to a large extent, we must call on the executive to respect the judiciary and Parliament and other independent constitutions, because as I've said, that the constitution that we have is not a constitution that would be implemented when you have some imperial thoughts sitting in State House. The president must drop the thoughts of imperialism, and his advisors must allow him to allow other institutions to operate hand in hand with the executive.
Absolutely, and I'd like to bring in Steve Ogola, who's a lawyer. Steve, when you see the unfoldings that have to do with the judiciary lately, this is not something new. We have heard all the antagonistic statements that have been made since 2017. What do you make of it? And is the shuttle diplomacy that has been spearheaded by Honorable Pogisio and Irungu Kang'ata the way to go in terms of trying to quell this sort of unrest between the executive and judiciary?
Thank you, Trix. Now, the standoff between the executive and the judiciary is now taking a dangerous turn.
How so?
That will in the long term or in the long run undermine the functional relations between the two offices, respect for each other, and undermine service delivery. For instance, the executive has struggled to assert itself and to control the judiciary by progressively slashing the judiciary budget.
Yes.
And the president blatantly refusing to appoint judges that have been nominated by the Judicial Service Commission. The judiciary, on the other hand, have also reacted very swiftly by openly telling off the president, and in the long run this will make the people feel antagonized. Because if you look at the president, he's the head of the political unit. And in terms of Article 129 of the Constitution, he draws his powers from the people. The judiciary, equally on the other hand, in terms of Article 159 of the Constitution, the judiciary also draws its powers from the people.
For sure.
So when you see the judiciary and the executive locked in a fierce supremacy battle, the unintended communication is the political unit or the electorate and the people from which these two institutions draw their power now are cornered into a position where they have to take a stand or take a side.
Yes.
Do they have to stand with the president, or do they have to stand with the judiciary? This is a situation that was not anticipated in the Constitution, that the people would have to choose between the presidency and the judiciary. It's a very painful experience to watch, and one that, if not checked, would undermine implementation of the Constitution and would affect the relationship not just between the executive and the judiciary, but also the executive and the people, and the judiciary and the people, including Parliament.
Yes, Mr. Ogola, when you say that we are forced into a situation where we have to choose sides, this is not how it should be, because at the end of the day, when people go to the ballot and vote, that should be the end of the story. They're giving you the power to execute whatever mandate they've given unto you, and particularly with the judiciary, that's to oversee some of their legal needs and some of the cases that are ongoing. And I understand right now there's a backlog, and a lot of problems that the judiciary is facing. But on the other hand, when you look at the winners and losers of the recent budget that was read, the judiciary was listed as one of the areas that were the losers. So it seems like while the judiciary would be meant to serve the people, and then we're having a situation that it is having to fight for even the funding for what it needs to actually execute that mandate, the people would obviously it would be unfair to say that it is the people to choose who to side with, because the people have their own needs that are directly not being met by the judiciary not being funded. Do you understand what I'm saying? And then we are having a situation where the backlog is not affecting CJ Maraga himself on a personal area, but you're having people with land cases and other issues that are having to actually suffer because the judiciary is not faring on well because of this particular spat.
I think, Trix, it is fair to say that the executive is out to control and emasculate the judiciary. Now, the judiciary is lacking allies. No one is speaking for the judiciary except the Law Society of Kenya.
Okay.
Parliament, as we know it today, is a mere extension of the executive. We all know that. This parliament has failed to rise independently and to assert its independence. It is unable to check the executive. So the executive has been able to control and influence parliament, and now it seeks to extend that influence to the judiciary. The judiciary is rejecting that maneuver. But instead of the people standing with the judiciary, the attacks on the judiciary have continued and abated, and now forcing the Chief Justice to step up the response and protect the judiciary in a perfect setting, Trix. We would not expect the judiciary or the Chief Justice, being the head of the judiciary, to speak in the same manner, in such a strong language, to the president. Because it undermines what we call courtesy and comity between officers. But if you look at the poisonous political context in which the judiciary is now operating, and lack of allies, Parliament, you have individual, you have single voices, such as Honorable Kajwang right there, who speaks in favor of the judiciary, but we are yet to see the Speaker of the National Assembly, the Speaker of the Senate, asserting the independence of their offices and calling on the presidency not to undermine overtly or covertly the independence of the judiciary.
Absolutely.
Yet when Treasury slashes judiciary budget, who approves that budget, Trix? It is the National Assembly.
Right.
We know in this financial year, judiciary has received less funding than the Nairobi Metropolitan Services. This just shows you the arrangement of priorities and the condescending attitude with which the executive considers the judiciary.
Okay,
But I want to advise the public.
Yes.
I want to advise the public that if there is a standoff between the executive and the judiciary, the judges have security of tenure. They have salaries. It is the Wanjiko, the common Mwananchi that are represented by members of parliament, that will indeed suffer. You've talked about backlog of cases. Judges are employed to clear those backlogs. When you deny them the human resource capacity, you deny them the budget to build courts, you are not in fact punishing the judiciary. The truth of the matter is you are punishing the electorate, which put that executive in office, which also put the legislature in office. So I think we need to reframe the problem. Judges are professionals. They are trained lawyers. In the absence of judicial work, they can do other works. But when they sit in those offices, they sit to serve the Wanjiko, the common man. I am not seeing the executive understanding that aspect, that when they are trying to sabotage the judiciary, they are in fact sabotaging Mwananchi.
Right.
And I'm not seeing the legislature, parliament, coming out strongly to appreciate the fact that the antagonistic relationship between the judiciary and the executive in the long run will hurt the common Mwananchi more than it can ever benefit the executive.
Okay, and I'd like to bring Honorable Kajwang into this. What would it take to have the judiciary have a sort of buffer zone that would be Parliament, to have them, someone else actually stand up for them? Because as Mr. Ogola has said, the CJ seems to be standing on his own and speaking out of frustration. It wouldn't take an expert to actually see that. What would it take for Parliament to actually stand in the way of certain budget cuts, of certain measures that actually hurt the judiciary and, you, of course, in a ripple effect, have an effect on the locals, the common mananchi that Parliament itself is there to actually speak up for?
The funding challenges, in my view, we've had this conversation around the Judiciary Fund and its operationalization, not just providing for it in the law, but making sure that it works in a manner that provides the judiciary with some functional fiscal independence, that it does not have to keep begging the treasury every other time. I think that was part of the proposals that were mooted when we were doing even the bill in bridges, and when the judiciary, the Chief Justice, made their recommendations on proposed constitutional and statutory reforms. The other issue is that this budget thing, really, we must take the blame as Parliament. And sometimes the manner in which we have used the committees that are relevant to that process has been wrong. You will find that we will fill our budget committees with political colleagues who will be out there to serve a particular story
agenda
or a particular storyline. We are now making changes in Parliament, and it is a conversation that is ongoing on the budget committees in the National Assembly and the Senate, so that we have budget committees that are thinking much more broadly than the narrow parochial political party positions. Another committee that is extremely important in the workings of the Judiciary Parliament is the Justice and Legal Affairs Committee of both the Senate and the National Assembly. The one we have in the Senate, there have been certain changes around leadership. It had been led for quite some time by my friend, Senator Gerard Kay of Nadi, but there was a feeling that we needed to have some change and inject a change of leadership. Gerard Kay did his bit. He led us as Senate to go to the High Court to seek determination on a number of issues. Even we in Parliament, when we feel aggrieved by the executive, we have been going to the judiciary. We have, as a Senate, and I believe that was part of the conversation between my majority leader and the Chief Justice on the status of some of the cases that the Senate has brought before the judiciary. We have taken exceptions. The executive has been signing into law particular acts or statutory provisions that touch on the whole governments without allowing them to be referred to the Senate. And we decided to take that matter to the court because we believe in it. Ultimately, we must ensure that the judiciary is well funded. Ultimately, we must ensure that the judiciary has independence. We must ensure that our Justice and Legal Affairs committees are working effectively and they're working hand in hand with the judiciary. And we must also tell the President that whatever he's doing to institutions is not right. That is not how to secure legacy. We cannot talk of uniting Kenyans by only bringing tribes to the table. Institutions must also come to the table. That is the best way of uniting Kenyans, because the judiciary is a protector and defender of Wanjiku. The legislature is the voice and the eyes of the people, and the executive is the one that holds the knife and the arm. These three must work together.
Absolutely.
One institution cannot purport to be bigger than others.
Okay, and they should work in a sort of harmony. But far from that, there has been recent events surrounding the judiciary as well, where a number of nominations for the position of judge were rejected by the executive owing to what was termed a questionable character. And obviously, by law, it is required that whoever is nominated should be above character. What do you make of that, especially that after these names were thrown back to the JSC, there was a bit of throwing of blame from one corner to the other on who actually is responsible for this situation?
To me, I believe that it's perhaps a failure of processes. By the time the JSC is doing their interviews and their vettings and doing their background checks, and they are not doing it on people who have come from another planet. They are doing it on people who have worked within the system, within the structures, within the corridors of justice. It is at that point that one should be able to pick issues with the candidates. Once you have gone past that point, the president's responsibility is to ensure that those other commissions and independent bodies, their decisions are upheld. There are many cases in which Parliament is also required to make certain decisions, which then would need to be ratified by the president. And we have seen, and a lot of this happened in the last Parliament, there was something that we used to call legislation through presidential memoranda, where the executive waits for Parliament to go through all the processes, including public participation, including debate, first, second, third reading, and both houses of Parliament come up with a piece of legislation, only for it to be overturned by a presidential veto, which is called a memorandum. That is not right. That is stretching the powers available to the presidency too far. Yes, the law could allow him to send back a memorandum to Parliament. It might not be expressly stated in the manner of the judicial officers, but in Parliament, the President has a backdoor to interfere with the decisions of Parliament, which then requires 2/3 to overturn it. I think the President is using his powers, is stretching his powers too far, and is doing it in a manner that interferes with the independence of those other institutions. In the case of the judicial officers, between the JSC and the presidency and the Attorney General, we expect as Kenyans that they must be able to talk to resolve this matter. Okay. The AG should not be talking back at the Chief Justice in public, because if he thinks that by the CJ talking to the President in public is demeaning, then it is further demeaning for the AG to step in and use words that are reserved for political rallies on the head of the judiciary.
Right, and we were all treated to those that back and forth between the three individuals. Mr. Ogola, when you, with regards to the nomination of judges, what did you make of that situation? Who was to blame? Was the executive being unfair for throwing these individuals back at the JSC, or did the JSC fail to actually do its due diligence and ensure that whoever is nominated is above reproach as far as character goes?
I think let me just clarify something before I answer that question.
Yes, yes.
There is a settled understanding that the executive is revisiting the judiciary. To argue otherwise is to lower commitment to common sense.
Okay.
But that is not the problem. The problem is the executive is emasculating the judiciary with the full support of the National Assembly. The way to hurt the judiciary is to defund it. So let us locate where the problem really lies. It is within the executive and the National Assembly that approves those budgets that cuts judiciary funding, which makes it impossible for judicial officers to even provide teas and snacks to clerks who come to court early to arrange the files, who denies judges printing papers, which makes it difficult even for judges to take notes in court, effectively cornering the judges and the judiciary in its entirety to a position where their voice is completely taken away. And that is what the CJ is fighting to resist. And I've said, in terms of that war, the judiciary is lacking allies.
Yes.
The first ally should have been the National Assembly and the Senate. Be it as it may, in relation to the appointment of the 41 judges, just to be sure, Trix, I argued this case on behalf of the Law Society of Kenya before a 3-bench judge. What the court said in relation to the appointment of the 41 judges is that the executive has no role at all in the appointment of judges. Theirs is merely to act. The president is merely to appoint because of his role under Article 131 as the head of state. He merely performs a ceremonial function of appointing. But if there was a legitimate concern by the head of state that some of these persons to be nominated as judges are of dubious integrity.
Yes.
The presidency has 4 persons directly under his control at the JSC. 2 persons representing the public, being a man and a woman, he has the Attorney General, and is the head of Public Service Commission. Sitting in the Judicial Service Commission, he could pass any intelligence or any adverse report that could help the JSC arrive at a decision that then reverses any intended nomination of those judges. The JSC in totality, in terms of collective responsibility, approved these names and then forwarded these names to the president for appointment. The president is not permitted under the law to reverse or to stall the appointment process. What he can do in law tricks is that upon the appointment of these judges, he can then refer that information that is within his possession. As soon as these judges have been sworn in, refer this information to the Judicial Service Commission. The Judicial Service Commission will immediately establish a committee to interrogate these allegations. When a committee is formed by law and by practice, tricks,
Yes.
those judges are immediately suspended. So it is possible to appoint these judges and suspend them immediately pending the review of these complaints. You see, within our constitutional design, the reason why the Constitution did not give the executive, the president, powers to interfere with the names is because we wanted to protect the integrity of the appointment process, reduce or remove executive influence in the appointment of judges, and ensure that the president only comes at the tail end as the head of state. But again, let me link that with what the Speaker of the National Assembly, Justice Muturi, told the BBI committee, the BBI team. Remember, Muturi, in his presentation to the BBI team, he suggested that the Judicial Service Commission should be composed by people appointed by the president. And he suggested that the Chief Justice should be appointed from a list of 3 names. So that's why I'm telling you that there's a scheme or a plan there's a conspiracy between the executive and the National Assembly to gradually take away the independence of the judiciary. And that is what the Chief Justice is fighting. Remember, the Chief Justice came out swiftly and told off the Speaker Muturi that the Speaker Muturi cannot speak for the judiciary when it comes to composition of the Judicial Service Commission, when it comes to composition of members of the judiciary in the JSC.
Right. Mr. Ogola, I'd like
So
to
you must
hold
understand this in the
you
proper
right
context.
there, because I'd like the people at home to understand what you are asserting. What does the executive stand to gain from getting this sort of influence over the judiciary that would be unchallenged?
This is a very important question that has political connotation. What the executive intends to gain is this. When you succeed in having a compliant judiciary, it is a huge investment for the election cycle or election period. Remember, the Chief Justice and the Supreme Court sit to determine presidential election petitions. When you systematically weaken the judiciary over a period of 5 years, at the time when you need to rely on the judiciary to make a fair determination in an election petition, you can be sure that you can get a compliant bench. So that is what the executive intends to gain.
Okay.
But a more important question of equally political relevance, the people must ask themselves, even as the executive or the presidency invest in 2022 election outcome, at what expense is the executive planning to preserve the outcome of an election? Because it means that in the next 5 years, cases will not progress, cases involving ordinary Kenyans will not progress, judges will be overworked, the budget will be cut, and then you will have a win, you will have the executive or the political elite that are able to preserve the outcome of presidential election, but during the 5-year term, the electorate will suffer a great deal. That is the context that Kenyans must understand this war between the judiciary and the executive.
They shall be the losers. Honorable Kajwang, just to bring you in as we approach the end of the conversation, I would like to know, what do you think the executive stands to gain from this sort of influence over the judiciary, and at the same time, the possible solutions? We had the shuttle diplomacy that you alluded to earlier on in the conversation. Is this key to ending the spat between the judiciary and the executive, and is there hope for a more collaborative approach towards dealing with the issues that are ultimately, as we have said over and over again, affect the common mwananchi?
I think the good intentions that the government has had, which was initially stated as uniting Kenyans, the Jubilee Coalition came together to bring communities that had been fighting for some time together, progressively, the BBI. We have started off with some good intentions, but we are sliding into a sense of Machiavellianism, a sense where one arm of government wants to dominate others for its own end and for its own benefit.
Yes.
And this is not useful. We must allow institutions to breathe. I think Steve is right that sometimes you need a bench that can render decisions in your favor. The president has been cited as saying that the government has imposed tax measures and the judiciary has shut down those tax measures. Ultimately, tax measures is not for the executive to go and pluck money from trees. It is for the executive to extract money from citizens. And so when the judiciary stands up on behalf of citizens, that should not be seen to be wrong. You see, there's another independent institution that we have also not given the treatment that it deserves. We don't have an auditor general. The last auditor general left office in August of last year. Who has been watching over government finances and government spending? So we did not promulgate the 2010 Constitution to return to imperialism or Machiavellism or a politics of the end justifying the means.
Yes.
Let us pay fidelity to the Constitution. Let us respect the people of Kenya by respecting that the institutions that they have put in place, and let this public spat between the judiciary and the executive be resolved in the spirit of the handshakes that we have seen in this country, because this matter is as important as the political contestations that we have seen in this country. Political contestations sometimes result in bloodshed and direct loss of lives, but a contestation between the executive and judiciary will result in loss of property, loss of moral and financial stability on the part of many Kenyans who depend on the judiciary to help as neutral arbiters in all matters and all conflicts that come before them. But I can assure the nation that we in Parliament, even as we reconstitute our committees, we will ensure that we provide this country with the best brains that can act as a bridge between these different institutions. We will ensure also that whenever we feel aggrieved, we do not go to State House to seek favors. We will go to the judiciary to ensure that there are judgments and rulings and pronouncements that are made for posterity. On the matters that the Senate took to the High Court, issues around presidential assent on bills that should have gone to both houses of Parliament. It would have been easy for us to go to State House and strike a deal and reach an agreement with the presidency. But that would have ensured that this country would not have had a well-reasoned argument, a well-reasoned decision that would guide future speakers, would guide future presidents, and would guide future legislators. We believe in the judiciary. We believe that the issues raised by the Chief Justice are valid, but we do not like the untidiness of the public's parts. But it should not be seen as a disrespect, because a man's got to do what a man's got to do. If Chief Justice has tried to resolve these issues amicably and they're not being resolved, then I think there's nothing wrong for him to take that direction. But on this, as a senator, individually, he's got my support. And as a Senate, I can tell you by and large, we agree with the issues he has raised, and we will do whatever we can going forward to resolve them amicably. Absolutely.
And Mr. Stephen Ogola, let's talk about the solutions. What do you think is the way forward in terms of ironing out the differences? Is it a go between the executive and the judiciary? What do you think of what the senator has said about possibly the attitude we should have moving forward?
I think litigation is not the solution. to the standoff between the executive and the judiciary, the Senate and the executive. What the Constitution anticipates is that all constitutional office holders should have a matching culture of compliance with the Constitution. Now, culture, sadly, cannot be litigated. Culture cannot be legislated.
Yes.
You have a constitution that requires a value-laden approach to implementation. But we live in a value-free society where implementation of the Constitution is not based on its aspirational needs, but on political convenience. The only time the judiciary and the executive will get to agree is if what the judiciary is saying matches what is politically convenient for the executive. The only time the executive will agree with the National Assembly is if the National Assembly does what the executive considers as politically convenient. The solution in the long term would be organized at the ballot. When you're organizing the political wing of government, the public need to be intimately familiar with the high calling of those offices and elect persons who are already co-opted into the philosophy of compliance with the Constitution, the philosophy of cooperation and collaboration. Otherwise, we will keep on going round in cycles, and after 20 years or 30 years, since 2010, we will be able to say that the Constitution of Kenya has not achieved the kind of transformation that was anticipated. In short tricks, observing the antagonistic relationship between the executive and the judiciary, one can arrive at a conclusion that our Constitution has failed to deliver the kind of changes it anticipated, and that our Constitution, in terms of practical effectiveness, is not any different from the pre-2010 Constitution. The solution of reviving the Constitution does not lie in fights. It lies in conversations, consultations, negotiation, but all this require a collaborative attitude and approach. Ultimately, we will have to wait for this government to finish its term, reorganize the government in 2022, and hope that we can get a government that is more compliant with the Constitution than one that is obsessed with its own political desires.
Right. Now, as we look forward to those collaborative times, I would like you to also talk about the way it's being handled. Do you think there's room, or rather hope, for more decorum, perhaps, in terms of how these two bodies are addressing each other, especially now that we have go-betweens right now that are hopefully going to have another meeting that would help iron out the differences between the judiciary and the executive?
The hope lies in people climbing down. So the Chief Justice must climb down and not use what is considered as strong language against the executive. It must document its grievances and communicate them with civility. The executive must climb down from its institutional arrogance and political quest for political dominance, and understand that we have a new judiciary that is ascendant, a judiciary that equally draws its powers from the people, and try to respect that institution. Parliament must also be more assertive and expressive. It must be able to speak as an institution, not as individual voices, the way Honorable Kajwang, Senator Kajwang, is speaking. We want the institutional voice to be dominant, not individual voices of members of the National Assembly or the Senate. When Parliament asserts its independence and refuses to be used as a rubber stamp,
yes,
then it can effectively check the executive. In the long run, we will have a judiciary and the executive and Parliament that is able to work together.
Thank you very much, Mr. Ogola. We have run out of time. Unfortunately, we have run out of time, so we cannot go on with the conversation. But we have had very valuable sentiments from Senator Moses Kajwang, as well as Mr. Stephen Ogola, who is a lawyer, giving us their insights on the spat between the judiciary and the executive, possible solutions on what this means for the common Mwananchi. We're going to take a short break. When you come back, we shall be taking a look at the Day of the African Child, and just trying to take a look at what difficulties they are facing right now. Schools have been closed, we are facing COVID-19, and so much more. Stay tuned for that.